Start. Inquiry was conducted and the inquiry officer found that the order passed by the delinquent officer amounts to review of the order passed by his predecessor in dismissing the miscellaneous application of the employer stop. Moreover, the employer in his second application did not refer to the filing and dismissal of his earlier application seeking for the same relief and further did not allege that his second application was beyond time and there was no discussion and finding in the order passed by the delinquent officer as to the ground on which the delay was condoned. Stop. In the conclusion, the inquiry officer held that the delinquent officer had allowed miscellaneous application number 37 of 1937 in the execution proceedings going out of the way to help the employer and to favor him, brushing aside the legal contentions and objections raised by the workman to the said miscellaneous application. Stop. Passage. The division bench observed that though the employer had not disclosed about his earlier application, the workman in his reply filed to the second application had disclosed the same and also produced copies of the earlier proceedings as evidence, and the omission to mention about the earlier application would not amount to suppression since facts were known to both the parties. Stop. The division bench further held that the finding of the inquiry officer that the delinquent officer had reviewed the earlier order is erroneous since the order passed by the delinquent officer was not in exercise of review jurisdiction and he never treated it so and rejected the conclusion of the inquiry officer that the delinquent officer did not properly appreciate the objection raised by the workman. Stop. In so far as the finding of the inquiry officer with regard to entertaining of time-barred second miscellaneous application of the employer in the execution proceedings and condonation of delay, the division bench held that the power to extend the period of setting aside ex parte award is conferred on the Labour Court under Rule 26-A, and though the delinquent officer has not stated so in his order, the appeal preferred against the said order was summarily dismissed by the High Court, and in the further appeal the parties have arrived at settlement and it renders the issue of limitation and condonation of delay more or less academic. Stop. The division bench was of the opinion that prima facie the delinquent officer did try to be judicious and it is sufficient to absolve him from charge. Stop.